harassment of women at workplace. And we have two distinguished speakers, Honorable Justice Hima Kohli and Ms. Rebecca John, who will give their views and enlighten us. Her leadership needs no introduction. Always smiling and relief for
क्या
ladies
क्लियर हो
judge.
गए तो
Her ladyship graduated from St. Stephen College. She did her law from CLC and got enrolled with Bar Council of Delhi in 1984. Her ladyship has practiced mainly in High Court of Delhi on civil and appellate side. She was standing counsel for NDMC and additional standing counsel for Government of Delhi. She was elevated to the bench in year 2006. So, for 14 years, ladyship has passed several landmark judgments and heard matters in almost all jurisdictions, be it civil, criminal, appellate, or arbitration appeals. She is the chairperson of many committees, including the Sexual Harassment Committee and High Power Committee, constituted by Supreme Court for decongestion of jail. She is also heading committee for restoring normal work of courts. As chairperson of decongestion committee, she has taken bold decision and has recommended the release of under trials 302 and 307 IPCs already undergone 2 years and 6 months respectively, and thereby upholding the law that bail is a rule, jail is an exception, and jail is only for convicts and not for under trials. I was reading Swami Vivekanand for this bold decision. I would like to quote these four lines for Justice Emma Kohli. This is the gist of all worship, to be pure and to do good to others. He who sees Shiva in the poor, in the weak, in the diseased, really worships Shiva. He who is served with helped one poor Shiva is seeing without thinking of the caste. Shiva is more pleased with you. So, ladyship, since you are the chairman of getting back to the normal work also, and our fraternity is financial distress, we expect a lot other bold decision as well. The other speaker today is Miss Rebecca John, one of the most aggressive, intelligent, and outstanding lawyer we have in Delhi, and she's practicing on exclusive criminal side since 1988. And among the long list of case to her credit are Jan Hawala case, 2G Spectrum case, Arushi murder case, and list is long. She is member of Internal Complaint Committee of Delhi High Court and is dealing with the complaints on the Sexual Harassment Committee. Thank you so much, and I am handing over now to Ajay, who will coordinate further. I welcome you all again, Swami.
Thank you, Ajayinder. May I now request Honorable Justice Hima Kohli ma'am to take this session.
A very good evening. I'm glad that I'm seeing so many of you virtually. Thank you for inviting me. I think now it is the new normal that till things get normal, we see each other like this, whether inside our homes through VC or in court through VC. That doesn't mean that the distances cannot be bridged. And this webinar is one of the initiatives which is bridging this distance. At least we can see each other. We cannot actually meet each other. And that also makes a difference, because end of the day, a social animal. It's also difficult to stay away. Frankly, I think just as you are all missing court or going to court, so am I. It's not easy to hold courts through PC, and the constraints of doing PC are a lot. So where we could do 40 matters, 50 matters a day, we are having to do maybe 10 or 12, and by the end of the day, one is really exhausted for various reasons. For connectivity problems at the end of the lawyer, sometimes, for example, today there was a power failure in my area, so there was no electricity. We had to hang on to electricity to come back to hold court, and there are so many challenges. But I am learning, I'm sure all of you are learning. It's a learning experience for all of us, and we must cope with the situation as best as we can. So coming back to the subject at hand, sexual harassment at workplace. Today is a when due to the COVID-19, anybody enters somebody's premises, there is many times, even courts, many institutions, the thermal gun. And what is that thermal gun? A thermometer to test whether the person is suffering from fever, to permit him or her entry. So many years ago, what did Swami Vivekanand say about this thermometer? He said that the best thermometer to test the progress of its nation is the treatment that it meets out to the women. And that holds true as much as it did then as it does today in the current scenario. So the focus of our webinar is what is one of the most debilitating programs that problems that women in India face while working, the problem of sexual harassment at the workplace. We all know that it comprises about half of the global population, which comes to about 7.59 billion people. And that makes a prominent part of the society. The census that the government had conducted in the year 2011 had revealed that there are about 48.172% of the Indian population were women, close to 50% again. In 2019, the labor participation of women has been to the tune of 20%. Then why are they not treated at par with their male counterparts in the spheres of life, be it at home or be it at work? Is something that we need to consider and examine. And it is not as if sexual harassment has been something new that has come up. It has been there for years together. It is rather ironic that while we all think that we venerate women, the deities we pray to amongst them are mostly women. We think that our mothers, the wives, the sisters, the bhabis, the female are sacrosanct. But how does the same set of men treat women outside their homes? And sadly, sometimes within the homes is the telling comment. And that is what makes for a society's general consciousness. So we are, as a society, unfortunately, notorious for ill-treating our women. And that goes to the instances of those days of Sati Pratha, the practices of dowry which even happen now, today, to female infanticide, to wife burning, to sexual harassment, to domestic violence, and again, sexual harassment at workplace. Another prominent feature of negative characteristics and strains of the society. So the reasons of such a deviant behavior against women are plenty. We all know that. And one of them, which is prominent, I would say, is the patriarchal mindset of our society that needs to be dealt with. It's ultimately all, according to me, the mind. If your approach to a woman outside your sphere of life is the same as it would be to any of you who are known to you within the family or within the social circle or within the friends, probably such a situation wouldn't arise. But unfortunately, there is a fine distinction drawn between those who you know and how one would behave with them and those one doesn't know and what would be the attitude towards those unknown persons. And that is where the call should be that we are to treat everybody equally. And when we talk of equally, then the Constitution comes into play. We have all the rights that are enshrined in the Constitution, be it Article 14, Article 15, Article 19, Article 21, you name it. And before this act, the Act of Sexual Harassment at Workplace came into force, we had only the IPC to fall back on. But gone are the days. Up came the Vision of the Supreme Court in the year 1997. And the Supreme Court laid down certain guidelines inspired by the CEDAW. The CEDAW being the Convention on Elimination of All Forms of Discrimination Against Women. That was adopted by the UN General Assembly in the year 1979. So those guidelines remain the barometer for testing the cases on the yardstick of sexual harassment. Till it took the legislature 16 years to enact this particular enactment, the Sexual Harassment at Workplace, in the year 2013. The scope of the act we all know is fairly large. The aggrieved woman can be anybody who's a woman, because it's a woman-centric legislation. Right? A woman of any age, whether she's employed or not, who lays an allegation that she has been subject to sexual harassment. Now, the other question would be, what is sexual harassment? The definition of the act, just to share with you quickly, it says somebody, it includes unwelcome and sexually tainted behavior, directly or by implication, physical contact or advances, demand or request for sexual favors, making sexual remarks, showing pornography or any other unwelcome physical, verbal or non-verbal conduct of sexual nature. So it's fairly broad, wide. It can cover a lot of angles which otherwise were not available if it was only physical, sexual violence or harassment. This act extends across the board to organized and unorganized sectors. It is expected that all organizations must have an internal committee and a local committee that is to examine complaints of sexual harassment. Now, who's an employer? Amongst lawyers, as a lawyer, anybody who you employ in your office would be an employee and you would be an employer. Simply because a lawyer is not paying any emoluments to a junior colleague, to any staff member, will not mean that he or that she is not an employee. She will remain an employee under the, as far as the definition of this act is concerned. So it applies across the board. Lawyers, juniors, probationers, court staff, stenos, apprentices, whoever is a woman working under you in your control will be entitled to invoke the act. And what is workplace? That workplace is not your chamber alone. It is not your office alone. It is anywhere where you send the woman to work or to go in the course of work. It could even include the vehicle to arrange for that lady to travel in to or for work. So it is again fairly open-ended. That takes care of the workplace. Now, how does this committee work? The committee under the Act is supposed to comprise of at least 50% women. I'll give you a ready example of the High Court Complaints Committee, of which incidentally my co-panelist, Ms. Rebecca Jones, Senior Advocate, is also on. This committee, when it was constituted, comprised of two lady judges, comprised of Rebecca John in place of an NGO, because normally an outsider is supposed to be associated with the committee so that you can't, as a committee, do any hanky-panky. You're supposed to be watched by somebody from outside. It also comprises of members of the staff. As for example, till March, till the lockdown, I was member of that committee. We had a registrar, lady registrar, who was also a member of that committee, besides me, my other colleagues, and Rebecca. So that's how it is balanced. And that balance is imperative so that everybody gives their input on how the committee functions. And also, recognizing that there is a sensitivity attached to the nature of matters relating to sexual harassment, it is necessary that it has 50% women, because a woman would not perhaps be able to completely open up and reveal the kind of nature of harassment she has suffered if it's an all-male dominated committee, which I'm sure as lawyers who understand. Now, coming back to another aspect, the privacy aspect. The committee is not supposed to reveal any of the proceedings which are private in nature and put it into any public domain, the press or the media, and that applies as much to the complainant as it does to the press. Because there is some kind of a privacy involved, which should not be violated. The Act mandates. I'm not going to go into the punishments because there are more the Act is there. End of the day, we are aware of the fact that punishment can go up to 1 to 3 years of imprisonment and fine, or both, if it is established under the IPC that there has been a sexual harassment. But that apart, punishments are by way of employer imposing conditions on the employee, the aggressor, by deducting salaries, by showing that maybe he's suspended, maybe his place of working is changed. It could also mean that he has to pay some kind of penalty if it is established. Statute, I must say, has balanced it. They have kept in mind that a woman complainant could also miss a kind or false of. So where it is established that the woman has done so, the aggressor is equally entitled to his rights under the Act. They have been protected. So the the duties and obligations of an employer are fairly large. I will not waste our time on that because I think mostly you can go to the Act and examine it. Of course, I've got it ready just in case somebody wants to ask something. My concern here is that how did our Council of India, our Council of Delhi, deal with sexual harassment by creating committees, by creating fora, by making available guidelines for women to go to. Unfortunately and surprisingly, I think many of us did not even know it once and interpreted that it is not the High Court for lawyers and it is not the Delhi High Court Bar Association or any bar association of the district court that would be the forum for entertaining a complaint of sexual harassment. The statutory body is the Bar Council of Delhi and the Bar Council of India. Bar Council of Delhi is supposed to have a set of guidelines and also have committees to look into two kinds of matters. One, relating to sexual harassment complaints received by it from its own staff members against another male employee. The other is regarding complaints by women lawyers against on sexual harassment. So there are two sets of complaints. We discovered that when the Afsan Pracha case took place and the Supreme Court issued a series of guidelines and directions, not guidelines, really directions to go to the High Court to examine whether there is a system in place for dealing with such a complaint. And the Chief Justice then constituted a committee, again comprising of, I was sitting in, which John was part of it, my other colleagues were members. We found that the Bar Council of Delhi did not have any system in place to deal with this. And the Bar Council of India did have some systems in place but not completely. So first thing was done was to invite the Bar Council of Delhi and the Bar Council to participate in the meeting with us and to ask them what had they done in the year March 2019. Now, as I understand, the Bar Council of Delhi geared up. It has got some rules and rules and guidelines in place. And it is a statutory body which must have in any case, because how will it deal with cases of sexual harassment? Once the committee that is constituted by the Bar Council of Delhi comes to a conclusion that yes, it's a case where sexual harassment has taken place, it is to recommend that to the Bar Council, and the members of the Bar Council will then pass orders as to what are the disciplinary proceedings they would like to take against them. And what is the remedy of the aggrieved party? If aggrieved by the punishment imposed by the disciplinary, he can file an appeal to the Bar Council of India. But we found that the Bar Council had rules for the staff, but did not have rules. So I'm sorry, there is interruption. Request all participants to mute themselves. It would help. Thank you. So the Bar Council of India was also requested to constitute a committee, and that is how today we have committees in both the High Court as also as the Bar Council of Delhi and the Appellate Court, which is in place, focused as per the internal complaints committee as required. For the High Court, we also have an internal complaints committee which I was referring to, that deals with complaints of the lady staff members against employees of the High Court. The High Court is also, this committee is also vested with the power to conduct inquiries with respect to any complaints of judicial officers, both the higher judicial services and the other. So any complaint of that nature that comes is referred to the committee. We have to examine it, to a preliminary examination. If we find that there is substance in the complaint, the party who is aggressor is put to notice, is called. We carry out an informal interaction for us to understand what exactly is the problem. After that interaction, and we are not talking of academics at that stage, we are only talking of interaction with both sides. And thereafter, and preferably not by calling both sides and confronting them with each other, by keeping that fine divide so that there is no embarrassment to either side. And then we proceed to evaluate and decide whether we should take it further, for which we then give a preliminary finding. And for that preliminary finding also we can invite us. by both sides to clarify their position if we have some doubts about the nature of complaint. We may be selective. The complainant may have made 20 instances. We may pick up a couple and think that we are satisfied this is enough for us to proceed further. That would depend on what the situation of the case is. Thereafter, the preliminary report is submitted and in the High Court. If it is a judicial officer, it is put up to the full court. On the recommendations of the court, it accepts it. Then a full-fledged inquiry is conducted under the rules, which means it is like a regular disciplinary inquiry. And then the whole gamut of proceedings can take place, which includes the petition, the affidavit by way of evidence, witnesses. But again, the informality to a large extent will be maintained, because this is not stricto sensu the court proceedings. It is a committee proceeding. So there is a lot of play in the joint standing. After the committee gives its findings, again it goes back to the High Court, full court. The full court mulls over what is to be done. The recommendation, if accepted, the full court takes a decision on any punishment to be imposed, puts the party to notice. If it's a judicial officer, if it is a staff, there is a proceedings that will go to the Chief Justice on the administrative side, and the Chief Justice will take a call. And that is how the whole process is taken. So, very quickly, I would end by saying, what is the way forward? The way forward is for firstly the legal fraternity to know that this is how a complaint is to be dealt with, which many of us till now didn't know till actually somebody lands up in trouble for food. And that shouldn't be. So even if somebody comes to you to help, to seek help, a lady lawyer, your own colleague, your own friend, somebody from your own family, you should know what to do and how to guide the person. It's very imperative. Secondly, you must realize that the Bar Council of Delhi and not the High Court of the Bar Association is the relevant body in a statutory decisions. And then one should also realize that the system should be transparent. Both the aggressor and the complainant should know where they stand and what kind of redressal will be available to them for the difficulties that may face. So the emphasis is on conducting webinars like this one, and I'm thankful to the organizers for organizing, so that all of us interact, discover the problems, discuss it with each other, and clarify our mind. And that is how we'll take it forward. Let us not forget, the legal fraternity is actually the conscious keeper of our society. And if they talk of principles of natural justice, fair play, and all that, then it lies with them to ensure that when it is a situation of a lady lawyer versus a male lawyer, then the balance should be there in a similar fashion. They should not be seen to be taking sides at that point, and be fair and square on how to deal with the matter. And that is why I think that it is the emphasis should be on publicizing all these issues, for knowing what the procedures are, for getting familiar with the rules in general. And besides legislation, the crying need of the time, to my mind, is change the mindset of male police. They must shed their apathy. They must adopt a proactive role to ensure that a woman police or a woman employee is respected at the workplace. They must go that extra mile to support those women who have the courage. And believe you me, it takes a lot of guts for a woman to step out and say that she was sexually harassed. Because most of the time, the stigma attached to her, she cannot shake. And then when she steps forward, support her when she speaks up. Thank you. I give it back to you.
Thank you. Thank you, Honorable Justice Kohli. It's been a very inspiring talk on this aspect. May I now request Senior Advocate Rebecca Ma'am for her experience in relation to handling the cases, and what are the tips for the victims and the issues which can be handled with your expertise, suggestions. Rebecca Ma'am.
Good evening. Thank you very much for inviting me for this webinar. And let me say that Justice Kohli and I have worked on this subject for a very long time. We've sat on cases, we've interacted with both victims as well as respondents, and we hope we were fair in the manner in which we finally conducted our proceedings. Now, any discussion on sexual harassment at the workplace in India cannot begin without an acknowledgement of the brutal rape and subsequent struggle for justice of Bhavri Devi. Women's organizations across the country came together to fight for justice in her case. And one of the offshoots of that struggle was a filing of a petition in the Supreme Court seeking to address the issue of sexual harassment at the workplace. The judgment in Vishaka versus State of Rajasthan was a huge victory for the women's movement. Its legacy is long and deep, and we are still not done with the struggle going forward. In Vishaka, the Supreme Court found that in the absence of enacted law to provide for the effective enforcement of the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly against sexual harassment at the workplace, guidelines had to be laid down. Now, I thought since Justice Kohli had given a complete overview of the Act as well as how internal committees work in reality, I decided to slightly shift focus to some of the frequently asked questions that worry most stakeholders, including women, as well as people who come up as respondents who are accused of sexual harassment. Now, one of the most frequently asked questions is, does only physical touch constitute sexual harassment at the workplace? If you were to look at the definition of the Act under Section 2N, then clearly no. The answer is no. Sexual harassment has been defined under 2N of the Act. Apart from physical contact and demand for sexual favors, Section 2N also talks of any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. Now, what is sexual harassment? Sexual harassment is deeply interlinked with power structures. It is an abuse of power, and it should be treated as such. It is used as a tool to control and sustain power inequalities. So when we examine a case, we look at the power disparity that exists between the complainant and the respondent. Workplaces very often lack diversity. Senior leadership is overwhelmingly homogeneous and is overwhelmingly male. Last year, India ranked 5th lowest in the number of positions. In the context of sexual harassment, wide power gaps could lead to hostile work environments where perpetrators feel like they can get away with their actions. So when we are examining what is sexual harassment, we also examine the inequality in the power structure. Another frequently asked question is, would it be sexual harassment if acts pertain to a personal relationship between an employer and an employee? Now, the Act does not talk about relationships. It only talks of sexual harassment at the workplace. But this is a complicated question, because if the personal relationship or the so-called personal relationship is predicated on what I spoke earlier, power structures, where, as Section 3 of the Act says, there is an implied or explicit threat which is detrimental to the complainant, either with respect to present or future employment, then this relationship has to be contextualized and seen in that larger context. So it's not enough to say that the respondent and the complainant were in a relationship. It is also important to examine that power structure. It is also important to examine whether the complainant was put under duress to enter into that relationship and how voluntary that relationship was. Another very frequently asked question is it still sexual harassment at the workplace when an incident of sexual harassment is perpetrated by an employee on a woman on an off-site visit for office work? Yes, Section 2O of the Act, which states that a workplace includes any place visited by the employee arising out of or during the course of employment, including transportation by the employer for undertaking such journey. The idea of the workplace is extended beyond just office hours. and it also includes any place visited by the complainant or the respondent arising out of or during the course of employment. Another question which is asked is it sexual harassment of the workplace when an incident of sexual harassment is perpetrated by one employee on another when they are not at the workplace? For example, they are sharing a car ride home or at a social gathering which is not sponsored or organized by the organization. Now, with respect to the car ride home, I would say yes, it is sexual harassment. But with respect to the social gathering, again, you'll have to go deep into the facts and circumstances of the case. Is the social gathering something that both of them were expected to be part of as an extension of their work? Or was it purely a private gathering? So again, we'll have to look at the facts and circumstances of the case. It is a slightly gray area at first shot, but it is not something which is impossible to determine once you are able to establish admitted facts. Can the internal committee take up a complaint against an employee after he has left employment? Section 11 of the Act actually answers this, where it uses the phrase where the respondent is an employee. Yes, it clearly envisages a situation where the respondent may not be an employee at this present point in time. The only express bar provided under the Act is that the time period for filing a complaint is 3 months. Of course, even that can be condoned. The delay can be condoned as per the Act. So even if someone has left employment, I do not see an express bar in the Act. It can still be picked up. Another question, where to appeal against the recommendations of the committee if no service rules exist? Now, in the context of lawyers, Justice Kohli has just now said that a report which has been prepared by the Delhi Bar Council, the appeal can lie with the Bar Council of India. Now, but there are many workplaces where the service rules don't provide for an appeal, but the Act and the rules, when read together, it clearly says that you can file an appeal with a court or a tribunal. Now, in Delhi, the industrial tribunal at Karkaduma courts regularly look into appeals with respect to those cases where the service rules don't provide for an in-house appeal system. Can a woman file a sexual harassment complaint with the committee if she is not an employee at the workplace? Now, Section 2A makes it very clear. It says that aggrieved woman means in relation to a workplace, a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. So the aggrieved woman need not be an employee. The aggrieved woman can be someone outside the workplace. And this has been clarified in several judgments of various courts. Another question, can an employer ask a new employee whether, so at the time of employment, can an employer ask the prospective candidate whether there were any cases of sexual harassment against him in the past? Now, if you were to look at the spirit of Section 19 of the Act, I would say, and I often advise clients, that perhaps it could be made part of the various questions you ask your candidate as a voluntary disclosure, whether he has been indicted for sexual harassment in the past, because that would determine whether or not the present employer wants to keep such a person in his employment or not. So Section 19 gives the employer fairly wide powers, and I would say that it is possible for an employer to ask of a new employee or a candidate who's applying for a post whether he has been indicted in the past or not. Now, what is the exact procedure required to be followed by the Internal Complaints Committee? Well, for government servants, the procedure is provided under Rule 14 of the CCA-CCS rules. So you follow that procedure. Justice Kohli has just alluded to it. And then it depends upon the service rules of every organization. What procedure should be followed when the incident happened long before the act came into existence, or long before even the Vishaka guidelines came into existence? Now, clearly, again, this is very discretionary. I would argue it would depend upon the gravity of the crime. But of course, you will require consent of both sides to examine something which is this old. So it is entirely at the discretion of the Complaints Committee whether it wants to condone delay from beyond the establishment of the statute or the Vishaka guidelines. It would be very difficult to go back in time. So normally complaints committees do not entertain complaints which are so old. Now, FAQ for lawyers. As a law firm, are law firms stopped from conducting an inquiry? No. All law firms which have workplaces as defined under the Act should, I would say, set up complaints committees in which both the women employee as well as the men the women can go and complain. The women can be the employees of the law firm. They can be clerks. They can be stenographers. They can be clients. And I would encourage law firms to set up internal complaints, because it would go a great internal complaint committees, because it would go forward to making a workplace which is just and equal, and where the woman feels safe. Can complaints be made against judges? Yes. And Justice Kohli will testify to this. We have taken up complaints, and we have taken it to their logical conclusion. They have been very robustly contested, and we have looked at these complaints very, very carefully. Is an employee only a full-time permanent employee for the purposes of the Act, or can temporary employees also be made respondents? Now, again, 2F of the Act has given a very wide definition to an employee and includes permanent, temporary, ad hoc persons, whether working for remuneration or not, and even includes volunteers or persons working through agents or contractors. Does a complainant have to select between remedies of filing a criminal complaint and filing a complaint under the Act? Not at all. Both can coexist. You can file a complaint before the Complaints Committee, and you can access the criminal justice system, and there is no bar, and one does not precede the other. One does not take away the right of the complaining woman from filing the other. What are the duties of the Complaints Committee vis-a-vis the complainant? Are there any duties at all? Well, not really, but it is always our endeavor to create an atmosphere which is not hostile, which is not adversarial for both parties. Members are expected to be sensitive, empathetic, aware of the various issues surrounding sexual harassment at the workplace. There is a handbook which the Ministry of Women and Child Development has brought out. It might be worthwhile reading that handbook. It must ensure that the inquiry is conducted in a time-bound manner. The Act says 90 days, and we should make an endeavor to complete the inquiry.
Now request Mr. Jatan Singh, sir, Vice President, Delhi High Court Bar Association, to give his concluding remarks.
Thank you, Ajay. My job was to say vote of thanks, which I will definitely do it now. First of all, Honorable Justice Hima Kohli, Ms. Rebecca John, Senior Advocate, and thank you both for joining us and agreeing to us to do this webinar. And the webinar is on a very important topic, that's sexual harassment of women at workplace. And when this topic was given, and then when Ajay spoke to me, the only people I thought of speaking on this subject was Justice Kohli and Rebecca. So I thank you so much for doing this webinar for us. I would like to thank Mr. Ajayinder Sangwan, member Bar Council of Delhi, who has spared his time, and that too from Karnal, and gave his opening remark. And I also want to thank the International Bridges to Justice India group, which is in these this COVID-19 situation. A group was started by Ajay, a criminal justice group, and it was started in this lockdown only. And I must appreciate and say thanks to Ajay that he has been providing great information to lawyers practicing on the criminal side. All orders passed by HPC, all orders passed by the Honorable Court regarding extension of interim bails and other things. The information is up to date on this. Now, I also would like to thank the participants who, because of without whom this webinar should have not been that successful. Then Justice Kohli was speaking. I came to know, and I was privileged that one of my cases, which was when I was standing counsel and decided by Justice S.B. Kar, and that case was mentioned in his reference, Linda Eastwood versus Union of India, 2014. It was a case from Calcutta where this woman was working, and this is a judgment which has been reported. When Rebecca was speaking, she spoke about Bhamri Devi and Vishaka's judgment. Yesterday only, I was watching a season of Woot, that is criminal trial. So there was a case of upholder publications, and this is what exactly Rebecca spoke, whether touch is considered to be a sexual harassment, or whether personal relationship is considered to be a sexual harassment at workplace. So all these issues were raised, and I saw it yesterday on Woot. It was a very good case. The lady fought from 2003 to 2014 when she finally got justice. It's a reported case. So I thank all of you for participating in this webinar, and I spoke my vote of thanks before the question answer session, because I knew that after question answer session there'll be a rush of leaving the webinar. So back to Ajay. Thank you so
Thank you,
much.
sir. Thank you so much. And I'm happy that the Bar Council of in Delhi as well as Delhi High Court Bar Association has shown their commitment